Hi everyone, welcome to part 15 of the revision lecture series on arbitration. In this video, we are going to discuss some of the disadvantages of litigation, and please note that this video, unlike the other videos in this revision series, is going to be a little bit longer than the usual length of videos in this series. Why? Because I thought that it is best to consider all of the possible disadvantages in the same video instead of breaking it down into separate videos. Please note that these are not the only disadvantages of litigation. However, these are a few that you should know, and you can include these in an essay question in your exam. In fact, in a timed written exam, you will not have time to write too much, so these few disadvantages that we are going to discuss, and which are the most famous and common ones, are going to be more than enough for your essay's content. So in this video, I am going to be discussing the 4 major disadvantages of litigation, and generally you should know that litigation, particularly in the business or commercial world, is considered as a method of last resort. The following are a few of the reasons why this is so, that is, why litigation is not viewed as the ideal method of solving a dispute. So, the first and major disadvantage of litigation is that it is slow and time consuming. In particular, in litigation, there exists an appeal mechanism, which means that a dispute may not be solved until the parties have exhausted all their possible appeals, that is, from one lower court to the higher court and then to the Supreme Court, which is usually the apex court in most countries. While the appeal mechanism of course has its advantages, however, this kind of mechanism usually results in prolonging an issue indefinitely, leaving the parties in uncertainty for a very long period of time, which is obviously not desirable, specifically in commercial and business situations. The second major disadvantage is that litigation, and commercial litigation in particular, is usually quite expensive and costly. And remember that in litigation, you don't only have to pay the lawyers from whom you seek legal advice prior to filing the suit in a law court, and of course pay more fees to these lawyers who are going to draft the suit for you. But in addition to that, you also have to pay the requisite court fees, which is in addition to the lawyer's fees. And what this means is that litigation is not something that every party can easily afford. The third disadvantage of litigation is that it can often be quite unpredictable. That is, you may never be sure which way or the other the judge is going to decide. And while this can, in certain cases where the law is indeed certain and there is a gray area and there is scope for development of the law, so in those situations, the parties are best advised to seek a resolution of their dispute through the litigation process only. However, in most situations, especially where the law is more settled, then in those situations it is best to stick to arbitration proceedings instead of getting involved in lengthy litigation proceedings where the results may not be so predictable. Last but not the least, one other disadvantage that may not be so obvious in the beginning but is definitely one that you should consider before filing a lawsuit is that it is usually best to avoid litigation if you want to avoid tarnishing the reputation of your business. And for many businesses, it is indeed crucial to maintain that positive image in the eyes of the public, and that is obviously not going to be possible if it comes to the knowledge of the public that a lawsuit has been filed against your business or company. And therefore, if you want to avoid damaging the reputation of your business, then it's best to avoid litigation altogether. So, to summarize, the 4 major disadvantages of litigation are: number 1, that it's slow and time consuming, especially because there exists an appeal mechanism which may prolong an issue indefinitely. Number 2, that litigation, especially commercial litigation, is usually quite costly. Number 3, litigation is usually very unpredictable. And number 4, that litigation ends up damaging the reputation of businesses, so it is best to avoid engaging in litigation proceedings. So now that we have looked at some of the major disadvantages of litigation, let us move on to consider the advantages of ADR and in particular arbitration. So in the next video, we're going to be discussing briefly the major benefits of ADR in general and arbitration in particular. Now, instead of ending this video right here, I'm going to add a few more points so that you have a more balanced view of this topic. First of all, remember that all of these disadvantages do not mean that ADR or arbitration in particular are processes that are necessarily always better than a court process. That is, that litigation always has these disadvantages. Because while there are these disadvantages, you have to remember to put the topic in perspective and remember that obviously there may be certain advantages to litigation which are absent in ADR processes or in arbitration proceedings in particular. The fact that there is an appeal mechanism in litigation is actually reflective of the fact that if a party is not satisfied with the decision of the judge, then a respected system ensures that there is a process for appeals available to that party. So yes, in certain situations, the court system, that is litigation, will undoubtedly be the primary choice for dispute resolution. On the other hand, there may be certain situations, especially when the disputes are between family members or between neighbors or even between friends, then in those kinds of situations, the parties may actually not prefer to get involved in court proceedings. So ADR processes may be ideal for those where the clients prefer more personal control over the dispute resolution process and of course more privacy as well. And if you're studying this course not as a part of a business law course, but instead as part of a legal education, that is, as part of your LLB degree, then you must remember that one major drawback of engaging in ADR processes instead of litigation is that this prevents the development of law through the precedent system. And if you are studying this course as part of an LLB degree, then I'm going to presume that you're already aware of what precedent means and what the precedent system is about. So in short, there are times where use of the appeal mechanism to either the High Court or the Supreme Court to resolve a point of law may be extremely important, especially where a gray area or a novel area of law is concerned and there needs to be further development in that area of law. However, I introduce these other points only so as to give you a more balanced view and a balanced flavor of the topic. And I'll leave it up to you to decide whether or not these points are important for the purposes of your course in light of the syllabus that has been designed for your particular course.